Your Excellencies, distinguished guest, Ms. Linda Fitz-Allen, ladies and gentlemen. Assalamu alaikum wa rahmatullahi wa barakatuh. I welcome you to this inaugural MESEA webinar series 2021, envisioned pursuant to the cooperation agreement signed on 3rd February 2021 between the Abu Dhabi Global Market Arbitration Centre and the Asian International Arbitration Centre. In my closing statement in February, I remember saying, the future looks bright between the ADGMAC and the AIAC. Bright indeed it is, as today I am pleased to inaugurate the MESEA Webinar Series 2021 aimed at ADR stakeholders from the Middle East and Southeast Asia. This initiative will include 5 events throughout the year with interesting topics such as i-Arbitration rules to be held today and the upcoming webinars on third-party funding, construction and infrastructure dispute resolution, renewable and non-renewable energy dispute resolution, and disputes in fintech and complex technology sector. In spite of the ongoing lockdowns around the world, this webinar series will help us collaborate efficiently on upcoming projects. To that end, I am pleased to welcome the esteemed speakers for this inaugural webinar, Dr. Thomas R. Klotzer, Professor Dr. Naila Kome-Obid, Professor Dr. George Afeki, Dr. Hassan Arab, and Mr. Abdullah Abdul Rahman, who will address the AIAC's unique product, i-Arbitration rules aimed at Islamic banking and finance disputes. The AIAC's efforts to promote this product is positive, and we had received the GAR Award for Innovation by an individual or organization in 2012 for the i-Arbitration rules. We will strive to ensure that the upcoming edition of the i-Arbitration rules sets new benchmarks and meets the expectations of the global Islamic finance and banking sector. I would also like to thank our collaborators, the ADGMAC, for their excellent partnership in shaping this initiative. This is a clear indication that Malaysia and Abu Dhabi stand together for the betterment of ADR in both regions. On that note, I invite all ADR stakeholders from the Middle East and Southeast Asia region to participate in these 5 webinars. By engaging in these discussions, we hope that you will not only encourage but also inspire both arbitral institutions to provide sector-specific dispute resolution services that meet new user demands in a post-COVID world. Thank you and stay safe.
Your Excellency Tan Sri Suryadi bin Halim Omar, ladies and gentlemen, good afternoon. I'm absolutely delighted to welcome you to this inaugural event of the Asian International Arbitration Centre and the ADGM Arbitration Centre's collaborative Middle East, Southeast Asia webinar series for 2021. It is with great anticipation that we are launching this series, which will be focusing on the topics in dispute resolution and those that we believe are of immense interest to this community. Since our very early discussions about how we could work together for the benefit of the dispute resolution industry, it was clear that the UAE and Malaysia are determined and invested in further developing their legal landscapes. Having signed our cooperation agreement with the AIAC at the beginning of this year, the series represents the beginning of many great initiatives and projects to come. It has been an absolute pleasure working with the dynamic team at AIAC, and I thank them immensely for their invaluable support in making this series happen. We believe this structured program will deliver positive impact for our communities and will foster a sense of collegiality and knowledge sharing. While working through the options for this series, we felt that taking a targeted industry approach would enable each session to deep dive into trends, challenges, and opportunities, and would allow the speakers and audience to walk away with thought-provoking insights, as well as having had the opportunity to engage with like-minded professionals. Today you will hear from the panel about the AIAC's innovative i-Arbitration rules, which we believe is a unique and highly relevant product for the benefit of arbitration practitioners in Islamic banking and finance. We have a panel of speakers with tremendous experience and expertise in this area who will talk you through the i-Arbitration rules and whom I'm sure you are well familiar with. To the speakers, I extend to you my most sincere thanks for so generously giving up your time and sharing your thoughts with us today. And to our audience, thank you for joining us. I know you will walk away from today having learned something valuable, and I very much look forward to seeing you at our next webinar. Stay safe and well, and I wish you all the very best.
Thank you, Tanshri Shuryadi and Ms. Linda, for such encouraging words. Now I invite the first speaker for today, Dr. Thomas R. Klotzel, joining us from Stuttgart to provide us an overview of AIAC's i-Arbitration Rules 2018.
Yes, hello. Can you hear me? I hope so. My microphone is switched on. Thank you very much for the kind introduction. I'm delighted to have the opportunity to speak to you on this interesting topics, which carries me through my professional life. You may be wondering how it comes that a Stuttgart lawyer is talking about Islamic arbitration, but that has the origin in our Singapore office, which I was heading in 1987 for my firm Tümmelschütze and Partner. And at the end of the 1990s, I was involved with a project finance issue where Islamic financing came up. So that raised my first interest. And then fairly shortly after that, the KLRCA, then known as Regional Center for Arbitration Kuala Lumpur and now known as the Asian Arbitration Centre, the Asian International Arbitration Centre has set up a set of rules which is trying to deal with the specific issues that arise when you have a contract where Islamic principles and Sharia issues and Sharia law issues may play a role. And for that purpose, in 2013 already, the i-Arbitration rules were adopted, which were reformed on 9th March 2018 in the current version. And those of you who are familiar with the rules of arbitration of the AIAC, I think you know that you have a specific set of rules which are defined in part 1. And then you have the Untitled arbitration rules of 2013, which of course are known worldwide and a respected set of rules. Now, I have a very limited amount of time to take you through the rules, and I will put my focus on a few issues which from my point of view, everybody should be aware of and which should be taken into consideration. If you look at the rules, we have the model arbitration clause, which is suggested by the AIAC, where I think one issue is important, where a choice of law clause is set out. And it makes reference to the substantive law, which a contract should be governed by. And that is exactly the problem, where when you now make a reference to Sharia law in that context, the academic problem, and of course academic problems result in practical problems also, is that Islamic law is belongs to the family of religious laws. It means that they are not territorial in nature, which is different from let's say Malaysian law, German law, or any other law. So that is an important point to keep in mind. The second next point in the guide, which starts the rules, you have just a few points which I want to highlight. The arbitral tribunal, the definition that is there, does not include the emergency arbitrator. But of course, the i-Arbitration rules also provide for the possibility to appoint, prior to the constitution of an arbitral tribunal, interim relief by way of an arbitrator. The next point in the definitions is the definition of Sharia counsel or Sharia expert. These must be persons who are qualified to issue religious rulings. So there is no particular definition as to that. So this clause gives a lot of flexibility, and this approach as to the selection of the particular counsel who will have to deal with a Sharia law issue, and I will come to that point at a later moment. Now, the next thing, if you look at the rules, the introductory provisions, what is important there in Rule 1, it is said that there's made reference to the opt-out provisions of the Malaysian Arbitration Act, which makes clear that the state courts cannot intervene in respect of issues regarding law, which I think is important to be aware of, that also in particular in Malaysia, you have a particular system of state courts dealing with Islamic law issues, but that is excluded. So the decision-making process remains in the realm of the arbitral tribunal. In Rule 2, you have the commencement rules with a fairly competitive registration charge of only €795. In Rule 4, and I only take you to the important points, it is defined as default provision that in the event of an international arbitration, which is also defined in a fairly standard manner, the arbitral tribunal will consist of a panel of 3 arbitrators, so that it is ensured in the event of a cross-border context that a panel of 3 arbitrators will take the decision. A fairly interesting feature is in Rule 5, dealing with the challenge of arbitrators, because there the IAC has a mechanism which is not, which you do not find in many institutional arbitration rules. It requires a challenge to be accompanied by a non-refundable fee of $5,300, obviously aimed to avoid, let's say, frivolous challenges to arbitrators, which we quite often see. Rule 6 then is also an important point, as it deals in its litera G with late payment charges. As we all know, under Islamic law, interest is prohibited. So in order to make an award debtor and to not give him benefits for his delay in payment, there is the possibility under the rules to award a late payment charge according to the principles of Tabid and Garama. So that is quite an important point. The further rules deal with consolidation, confidentiality, joinder, and of course, and that is a point where I will now put some focus in my last 4 minutes, is Rule 11, which is the procedure for reference to Sharia Advisory Council or Sharia expert. And I think that is the core point where any arbitral tribunal to whom a dispute is submitted where the application of Sharia principles is warranted will have to look at. First of all, I think what is important in Rule 11, subsection 1, is that the arbitral tribunal may refer the matter to the relevant counsel or Sharia expert. That means that unless there is in the territorial law, which applies to the contract, a request or a requirement that the arbitral tribunal or an arbitrator has to refer a matter to the relevant counsel or Sharia expert, the arbitral tribunal is free to take a decision I think in Malaysia, we will hear that there is a compulsory provision. So there, the Central Banking Act clearly says has to refer or shall refer. So that is clear. The second point in subparagraph 2, the Rule 11 says in litera A, the Sharia Council under whose purview shall Sharia aspect to be decided falls. I'm not sure whether this term is really meaning what it reads to me. I think the proper language should be ascertained, because in particular from a Malaysian perspective, it's clear that the task of the Sharia Council is to ascertain the contents of Islamic law. And I think that is completely different and also important from the perspective also from the UN Convention, that not the Sharia Council or the expert takes a decision, but gives guidance on the ascertainment of the Sharia law question in issue, which has to be decided. So that is something which I think is most important, because we all know, and that I think, and here we have to bear that in mind, that under the New York Convention, it is not possible that you vest the authority of the arbitral tribunal to an expert or a Sharia council. It will only be allowed to apply the law in accordance and after a substantiation of the relevant facts and applying these facts to a certain ascertainment, so that the decision-making process must be vested and remain with the arbitral tribunal. We then have the point, and that is also an issue where I think one has to be very clear about it on the qualification of what the ruling of the Sharia Council is. I think what we see in the Rule 11, there is the attempt to make sure that the council or the Sharia expert may make a ruling on the question or issue so submitted. So it is the task of the parties jointly with the arbitral tribunal to determine the terms of reference. And the AIAC, Rule 11 also says that the council shall deliver its ruling within a period of 60 days. So we don't know exactly what has happened, but what happens if no such ruling is provided. Subsection 7 gives an answer. The arbitral tribunal may proceed to determine the dispute and give its awards based on the submissions it has before it. So I think that is a very important point. So the rules aim to allow an arbitral tribunal to come to conclusions and to take a decision. And of course, what is also of importance is subsection 8, where it is clearly stipulated in the language, and the parties, by agreeing to the AIAC rules, they have accepted these provisions, so that party autonomy stands behind that subsection 8 of Rule 11, that the question and decision is vested only in the arbitral tribunal. I already took more than 10 minutes. I'm at 12, my watch, so I stop here. And thank you very much for your attention, and I'm happy to give further information. Thank you.
Thank you, Dr. Thomas, for such a comprehensive overview of the AIAC i-Arbitration Rules 2018. Now I invite the second speaker for today, Professor Dr. Naila Komer Obaid, who is joining us from Beirut, who will discuss with us a case study addressing issues concerning the applicable law to the merits, as well as the procedural issues under the law of the seat UAE.
Good morning, good afternoon. I am delighted to be part of this webinar organized by ADGMAC and IAIC and with very distinguished speakers. Thank you very much for your presentation, Abinash. I will tackle the two questions and I will submit to the audience a case study. I will start by the background. A British APC contractor required financing to carry out a contract for the expansion of a food processing factory in the UK and applied to a KSA-based Islamic bank for a financing facility of £60 million. The food processing factory handles different types of food products, including chicken, beef, and pork. In its application for the facility, the contractor only stated that the purpose of the facility was to fund the expansion of a food processing factory without specifying that such factory produced pork products. The Islamic Bank did not make further inquiries in this respect. The project was reviewed and duly approved by the Islamic Bank's Sharia board, and the contractor was informed that the facility would be provided via a commodity murabaha contract. Concerning the relevant contractual terms, they are as follows. Delays in payment are subject to ta'weed as determined by the Islamic Bank. Governing law is Islamic Sharia principles and English law. Arbitration is seated in Dubai. 3 arbitrators and the chairman should be knowledgeable in Sharia compliant financing. Now turning to the problem, following the grant of the financing, the expansion project commenced and the contractor began to execute its works. 1 year into the project, the employer decided to implement significant design changes and was required to obtain zoning approvals from local authorities. When the local authorities reviewed the employer's application for the revised design of the factory, it was discovered that part of the plant infringed residential zoning boundaries. After long negotiations, the local authorities ordered that the infringing part of the factory be demolished. Following the issuance of the demolition order, the employer terminated the contractor's contract. As a result of the termination, the contractor informed the Islamic Bank that it would not be able to settle the amount under the Murabaha contract. The Islamic Bank, therefore, exercised its right under the Murabaha contract to demand immediate payment by the contractor of the amount due upon termination of the construction contract. The contractor advised that it was not in a position to satisfy the Islamic Bank's demand. Each party appointed an arbitrator, and the 2 arbitrators appointed a professor of commercial law. I should mention that the applicable rules were the IA rules of that you are referring in this seminar. Now turning to the questions with respect to the issues related to the applicable law, to the merits. A potential claim from the party was regarding application of Sharia law. As you know, the application of Sharia law to the dispute, even when the contract includes such provision, may be a challenge under certain circumstances, in particular before national courts of secular states. Difficulties illustrated in the decision of the well-known Beximco Pharmaceutical versus Shamil Bank of Bahrain. In that case, the governing law clause in the underlying Islamic finance agreements referred to both English law and Islamic Sharia, which led the appeal court to conclude that an English court may not adjudicate a contractual dispute according to a non-national law such as Islamic Sharia, and the general reference to Islamic Sharia, and I'm quoting, in the applicable law clause was not sufficient to incorporate any specific identifiable rules of Islamic law into the agreement. Consequently, the dispute has been adjudicated by reference to English law only. Now, why arbitration? Arbitration with contract to a local court provides flexibility. This flexibility is offered to both arbitrators and to the parties, and in arbitration cases, application of Sharia law principles were upheld. I refer in this respect to the ICC arbitration case, very well-known case, Sanghi Polyester Limited versus the international investor KCFC Kuwait, is a perfect example to compare the attitude of courts and arbitral tribunals under similar circumstances. In this arbitration case, similarly to Beximco case, the contract stipulated that it was governed by English law, except to the extent it may conflict with Islamic Sharia, which shall prevail. And the seat of the arbitration was London. The sole arbitrator appointed to adjudicate the case relied upon the English Arbitration Act, 1996 Act, which expressly authorizes an arbitration to adjudicate a dispute in accordance with the law of a country, and I quote, or in accordance with such other considerations as are agreed by the parties. I now turn, because of the time constraint, to some procedural issues that should be taken into consideration under the law of the seat. Familiarity with the arbitration law of the seat, including mandatory provisions, is key, in my view, notably to ensure that fundamental principles such as due process are preserved. The arbitration seat was in Dubai, and here we should take into consideration the UAE law, the new law, which concerns also witness testimony. And I refer to Article 33(7) of the UAE law, which provides, unless otherwise agreed by the parties, the hearing of witnesses, including experts, shall be conducted under the law of the state. And this is a very good recent development. Therefore, if the law of evidence of the UAE applies, then the oath must be taken. But if the seat is in London, the oath is not required. I would like also to refer to Article 28(2)(b), which states that hearings or deliberations may be held by all means of communication and modern electronic technologies, enabling a new tool for conducting virtual arbitration in Dubai, and this is an excellent improvement. I will refer also to the grounds for annulment of an award under UAE law, arbitration law. UAE arbitration law is in line with the UNCITRAL model law. The UAE arbitration law, however, added morality as a ground for annulment under Article 53(2)(b), which provides that the arbitral award is in conflict with the public order and morality of the state, and in this respect, if the arbitral award is in conflict with the morality, the award could be set aside. What are the lessons to be learned? The lessons to be learned are important. And here I would like to refer to issues regarding enforcement of the award. And in case the award is to be enforced, in Saudi Arabia. There are several grounds for challenges. The first challenge with respect to the presiding arbitrator. The presiding arbitrator was not knowledgeable in Sharia law. He was only professor of commercial law. We should be very careful with respect to the constitution of the tribunal and in order to be in compliance with the parties' agreement in this respect. The object of the contract, prohibition of operations under Sharia law, notably pork products, and in that case, inclusion of interest in the award for the benefit of the contractor, and interest, as you know, is prohibited under Sharia law. In my view, what are the drivers for the increase of use of arbitration in Islamic finance? Firstly, the flexible application of Sharia law as a suitable law applicable to the merits in combination with a national legal background or regime. Arbitration is a gateway to internationalization of the Islamic finance sector. Arbitration provides legal certainty and expertise, safeguard for access to justice, and safeguard for the enforcement of the award. As a conclusive observation, I would like to highlight that education in Islamic financing outside Sharia-based jurisdiction need to be expanded. While presiding the Chartered Institute in 2017, we introduced the first international diploma course in Islamic financial products in Malaysia. It was a 9-day course. I urge institutions to educate in Islamic finance, because I expect that there will be a lot of disputes referring to Islamic products. So expertise of arbitral panels in Islamic Sharia is very important for enforcement of award in certain circumstances, as well as choice of arbitral institution. And I would like here to commend AIAC for their arbitration rules of 2018, because they are innovative and very creative. Thank you for your attention.
Thank you, Dr. Naila, for explaining such complex applicable rules and procedures in such an articulate manner. Dear attendees, Dr. Naila will not be able to join us today later during the networking session, as she has an arbitration in the next 20 minutes. So if you have any questions for her, Dr. Naila, you can feel free to directly email to her. And with that note, I would thank Dr. Naila for her participation.
Thank you very much.
Thank you. Now I invite the third speaker for today, Professor George Afaki, who is joining us from Paris. He will share his expert and arbitrator's experiences on application of Sharia and Islamic finance sector disputes. Professor Afaki, you have written and lectured extensively about the characterization of Sharia as a rule of law. Why do we rarely see Islamic finance contracts referring to Sharia as the applicable law?
Assalamu alaikum wa rahmatullahi wa barakatuh. This is an excellent question to start with, and I hope that you will not count it on the 10 minutes that you have generously offered me to cover a topic that would easily take at least 10 times more. Let me start by expressing my gratitude to the organizers for offering me at least 2 reasons to be a joyful man today. First, expressing concretely my gratitude to AIAC and to ADGMAC for hosting me on their roster list of arbitrators for such a long time. This is an opportunity for me to express my support for their wonderful educational projects throughout, and second, for the chance of joining such a distinguished faculty. In the very strict time that you have offered me to cover this topic, I will try to do my best to address 3 issues, probably leaving a lot outside, but then we can come to that in the Q&A session, hopefully. I will first start by addressing the important issue of how does Sharia come to interact with international arbitration? And second, where do we find Sharia when we sit as arbitrators and we have to argue Sharia as the applicable law? And third, are there red lines that we should not transgress if we apply Sharia in an international arbitration and we want to make sure that our award would withstand an annulment procedure and have a chance fairly to be recognized and enforced under the New York Convention? Let me start with the first question. And there are at least 3 titles under which Sharia can come to apply in an international arbitration. First, as the national law of countries that do not have a comprehensive drafted statutes. This is still the case of the Kingdom of Saudi Arabia. It has started a very ambitious codification campaign with Vision 2030. It is now in the process, quite advanced actually, of drafting a civil code. But until the Saudi civil code sees daylight and is enacted, the civil code in the country is still Sharia. A second title, and very often colleague arbitrators and more importantly counsel omit to refer to that in their cases, and this is unforgivable, is that Sharia is the main auxiliary source of law under a lot of national laws. So if the applicable law to the arbitration is Syrian law, Iraqi law, Kuwaiti, Emirati, Libyan law, then in the absence of an explicit provision in the statute or in the civil code, Sharia applies. You should remember that. It can come very handfully, not only when there's a real silence in the civil code to the applicable provision to the case, but also to nuance what could be too harsh a provision. Recently, I had the opportunity to argue a case under Emirati law, where I was asked to look into Article 313 of the Emirati Federal Civil Code, which provides that the employer is responsible for the acts of the employee. This is a principle that comes from the French Civil Code. It is not a Sharia rule. Under the Sharia rules, as I'm sure you will all recall in Surah Al-Fatir, وَلَا تَزِرُ وَازِرَةٌ وِزْرَ أُخْرَى. The principle is personal liability, not vicarious liability. And I argued that to the tribunal, not to indicate that Article 313, which is an explicit provision in the Federal Civil Code of the Emirates, should not be applied. Of course, it must be applied, but it should be considered as the exception to the general rule that should be seen in the Sharia. And it helped, of course, that the Emirati constitution provided that Sharia is the fundamental law of the land. And the third title for the application of the Sharia is where the parties indicate that Sharia is the applicable law. This is too rare. It is unacceptable. In international contracts, people must remember that Sharia, when it comes to fiqh al-mu'amalat, so let's set aside for now fiqh al-ibadat, which is outside the realm of international business transaction. Fiqh al-mu'amalat has enough detail and enough resources to provide a comprehensive legal system that applies to the contract. And I have argued in a number of scholarly papers and in a report that I submitted to the French government in 1999 that Sharia fiqh al-mu'amalat should be accepted, just like the general principles of law and lex mercatoria, as non-national applicable law to the contracts. But I would like to see more of that in the contracts. And the question that comes then, and this is my second point, is where do we find Sharia? And I'm tempted to remind everyone of the answer that was given by the architects of the Petronas Twin Towers, Manara Petronas, during the inauguration in 1999. On that wonderful day, Fazur Rahman Khan and Cesar Pelli were standing in front of the Twin Towers, wonderful towers. And they were asked, well, gentlemen, what is your greatest achievement? And their answer was, look around you. And of course, the Petronas Towers were overlooking everyone else. And I wanted to indicate that it's important that when we talk about where do we find Sharia, you do not consider that Sharia is like the French Civil Code, which all stands in 2,593 articles. That's not the concept of Sharia. And this is one of the wealth of Sharia. It starts with the immutable sources, which are the Holy Quran and the Sunnah. But then you have very deep and limitless opportunities to adapt the general rules to the case which you have in hand through all the means which are offered to you by the fuqah, which are the qiyas, al-istihsan, and al-istislah, which will allow you to apply from the general rules the solution to the case in hand. And if you are one of those who like always to stand on something solid and have a precedent, well, I advise you to start by looking at the AIAC standards, the Accounting and Auditing Organization for Financial Institute. And the AIAC has been issuing regularly standards that codify some, but certainly not exhaustively, Islamic Sharia as it applies to financial and commercial transactions. We stand now at 57 standards. They are all drafted in accordance to the very distinct way of AIAC of drafting standards, which is syncretic. All schools of thought are welcome to contribute to the drafting of that standard. Public hearings are organized. It takes ages for a standard to be finalized and issued, but when it is issued, I submit to you that it will offer you all the authority that you need to apply them. And right now, AIAC is working on extremely important standards, and I expect them to be disclosed within the next few months. One about the special purpose vehicles, which is at the heart of project finance. Another one is about debt, al-diyun. So I would warmly recommend that you look at them as well. And my last point is, are there some red lines that should not be transgressed to make sure that an arbitration award in an international context that applies Sharia withstand a potential annulment challenge or stands a chance of being executed? Well, an arbitral award applying Sharia is first and foremost an international arbitral award. So whatever is provided in Article 5 of the New York Convention will apply to that award as well. And as you know, the New York Convention is a true success in the international world because it has been ratified so far by 167 countries. It is an immense success. But I would add more specifically to Sharia a number of cautionary notes that we as arbitrators should remember to heed so that our award would stand the chance of being recognized and enforced. First, you will recall that in Surah Al-Baqarah, a very important surah in the Holy Quran, you have in paragraph 282, and I will cite only part of it because of the limited time, وَاسْتَشْهِدُوا شَهِدَيْنِ مِنْ رِجَالِكُمْ فَإِنْ لَمْ يَكُونَا رَجُلَيْنِ فَرَجُلٌ وَامْرَأَتَانِ مِمَّنْ تَرْتَضُونَ مِنَ الشُّهَدَاءِ. If we were to find a situation where the arbitral tribunal were to deny any evidentiary value because the witness is a single woman without any other reason to doubt the veracity, the authenticity, and the honesty of that woman's testimony, then that award will probably not have a great chance of being enforced elsewhere. Evidence is evidence. It has to be looked at with an open mind, and there's now a trend to interpret that part of Surah Al-Baqarah in a pragmatic way where starting, and this is obviously the great thing about qiyas, there are several areas that are peculiar to women, for example, birth, where the testimony of women is sufficient, and based on qiyas, I would suggest that this should be sufficient to grant evidentiary value for the testimony of a woman. Another point that you should keep in mind is a broadly held view, and I very much doubt that an arbitrator is an agent. And when you talk about an agent, then the agent is revocable. So the principal can revoke the agent, which is obviously anathema in matters of arbitration. And I think this is a confusion between a conciliator, muslih, and an arbitrator. Once an arbitrator is appointed, you cannot revoke him. And if there were to be a case where the enforcement court were to find that a party has exercised pressure on a tribunal by threatening revocation, that could be a problem. And another point, if I may, and I apologize, I'm probably getting close to my 10 minutes. Shall I carry on with my two last points, or shall I leave that to the Q&A? I see you nodding, so I expect that you're generously offering me 2 more minutes. I'm grateful for that. The third point is the debate about whether non-Muslims have jurisdiction over Muslims. I would not look at that in absolute terms. First, because the very basis in Sharia is something that I would urge everyone to look at more broadly. And back to my favorite surah in the Holy Quran, Surah Al-Baqarah, I would draw everybody's attention at the part 140 of the surah, where the testimony of non-Muslim Jews and Christians is accepted, and as is wonderfully indicated in that part of the surah, أنتم أعلم أم الله ومن أظلم ممن كتم شهادة عنده من الله وما الله بغافل عما تعلمون. So based on the qiyas, what is accepted in terms of testimony, I would suggest should be accepted in terms of the jurisdiction of the arbitrators. And perhaps this is a case where we should distinguish not only on the basis of whether the arbitration involves a non-Muslim party. And I would like to remind everyone of a precedent from the Sunnah, and this is accounted for in the wonderful Tafsir al-Khazin, and the full title of the book is Libab al-Ta'wil fi Ma'ani al-Tanzil, drafted by Ali bin Muhammad al-Khazin, where he reports a story of the earliest days of the Islam, where Prophet Muhammad sallallahu alaihi wasallam and his early followers had a dispute with a non-Muslim tribe. And Prophet Muhammad said, well, let's find an arbitrator to resolve peacefully this case. And we accept that the arbitrator would come from your tribe, the non-Muslim tribe. And that arbitrator handed down the award, and that award was willfully carried out. So I would suggest that we would not look at whether one of the parties to the dispute is non-Muslim to uphold the nomination of a non-Muslim arbitrator. This is often read. I would suggest that we should look more importantly at what the subject matter of the dispute is. If we are not strictly in the area of ibadat, but more in the area of muamalat, I would suggest that we should not doubt the jurisdiction of one of the arbitrators being a Muslim. And my very last point, if I may, is to come back to Rule 11 of the Islamic arbitration rules that Dr. Klotzel has mentioned. I have been reflecting on this article with some puzzlement, I have to say, for a number of years. And there are two ways to read that article. The first way, and I favor that way, is the permissive way of reading it, where I would put the stress on the word may. The arbitral tribunal may refer the matter to the relevant counsel or Sharia expert for its ruling. This permissiveness would allow me to suggest that Rule 11 would lead to a situation which is no different from one where the arbitral tribunal would consider that it would benefit of appointing an expert, so a tribunal appointed expert. And this would leave all the discretion to the arbitral tribunal to apply or not, to seek guidance or not from the recommendation of its own appointed expert, and in this case, that would be the Sharia expert. I would be very concerned if this permissive reading were not to be the one that is upheld, and if someone were to suggest that Rule 11 shackles the hand of the arbitral tribunal, and whenever there's a contested issue of Sharia, the arbitral tribunal is required to suspend the proceedings, turn over the case to the Sharia Advisory Council or the Sharia expert, and be bound by what that expert would provide. I see no reason why such an extreme recommendation of reading were to be upheld. If that were to be the case, then I doubt very much that the award would be enforced. This concludes my remark. Thank you for the extra minutes.
Thank you, Dr. Afaki. You truly spoke like an expert, and the views that you have given to us will definitely help not only members of the audience, but also AIAC. We really appreciate it. Now, I invite the fourth speaker for today, Dr. Hassan Arab, who is joining us from Dubai to provide us with the Middle East perspective on Islamic finance arbitrations and enforceability of awards in the region. Dr. Hassan, in your experience, what is more effective? Is it litigation or arbitration in Islamic finance disputes?
Well, many thanks, Avinash, for this question. First of all, I would like to thanks the AIAC and ADGM for giving me the opportunity to be part of the distinguished panel, actually, to be part of this lovely panel. Going back to your question, litigation or arbitration, I'm practicing both, actually. Originally, I'm coming from the litigation background. I'll tell you, I'll be very frank with you. Actually, we've seen Islamic finance disputes in front of the courts here in UAE. And I can say, although actually the most of the decisions were on the favor of the Islamic institutions, but when it comes to the matter of applying the Sharia principles, I doubt, and I never seen that the court will apply the specific rules of Sharia. They will look at the case from the contractual dispute, will see the obligations of both parties, and based on that, they will decide. But when it comes to, as I said, to the Sharia, they will never, and I don't blame the court, actually, because can you hear me, Abinash?
Yes, Dr. Hassan,
Yeah,
we can hear you
okay.
now.
I believe something happened in between. I cannot blame the court, actually, because, you know, Sharia, it's a complex matter. Most of the disputes under Sharia, you have different thoughts, you have different schools, you have different opinions. And I believe it's very rare to find a judge who sitting and he's basically a specialist in Sharia. In addition, although actually in the normal commercial disputes, the courts normally use the tool of referring the matter to the experts, we don't have the, or it's rare also to find advisory council specialist in Sharia similar to what you have in Malaysia. So going back to the question, arbitration or litigation in Sharia disputes, I personally prefer arbitration. You know, the general rules, why basically I'm referring to arbitration. Confidentiality is one, parties' autonomy to select expertise to decide on their disputes, to decide the law, the rules, the seat is another tool. The third thing actually is the enforceability of the award, which is very important tool. When it's you know, you have the New York Convention on one side, the federal law in UAE, for example, helping a lot, and we will come to this when we will talk about the enforcement of the award.
Thank you, Dr. Hassan, on that. So then comes the relevant question when you talk of enforceability. Are Islamic finance awards enforceable in UAE?
To be very direct, yes, because Sharia is one of the main source, as mentioned by Professor Afaki, not only in UAE, but most of the countries in the region. I believe yes, because you have New York Convention in one side, if it is a foreign arbitral award. You have the federal arbitration on the other side if it is a domestic award. And as highlighted by Professor Naila, the federal law was one of the important law we had it in 2018. And since we had that law, the court attitude towards the arbitration in general is more friendly. It's very rare to find that the court will annul the award. So going back to your question, yes, of course, it's enforceable. Unless basically the normal, if it is contradicting with the public policy, and it's very rare, as I said, since we applied the new arbitration law. Other than this, I cannot see any reason why the court will not enforce the arbitration award under the Sharia law.
Thank you, Dr. Hassan, on that. This brings me to my last question to you, and then we had also discussions about this previously. Do you have any recommendations for specialist arbitral institutions for set of rules, maybe arbitration rules, that address Islamic finance disputes?
Maybe we heard also from the previous speakers, Professor Naila, she highlighted something, Professor Thomas and Professor Afaki. But I have 2 or 3 things maybe as a recommendation. One is for the arbitration institutions, it's good actually to have a specialist arbitration institution dealing with the Islamic finance. And this is very normal, by the way, in the arbitration field, because we have some institutions dealing with the maritime cases, such as LMAA in London, AIAC in Dubai, in Hong Kong, similar. Some of the institutions, they are providing set of rules dealing with the specific matters, like the investment arbitration. SAIAC, I believe they introduced set of rules dealing with the investment arbitration. It's good actually, but the rules itself is not enough. You need to update these rules, and we can see actually, especially the past 2 years, and especially during the pandemic, ICC, they applied some new provisions. LCIA did the same. Here in UAE, actually, we have some institutions, they are working to amend the awards. So updating the rules is very important. Having the list of good arbitrators, especially when we are talking about the Islamic finance, it's not a matter of being aware of the procedures only. Having the background of the procedures is one tool. The other tools is having a good background about the finance, banking and finance, and Islamic Sharia. Because you will find, as I said, actually complex cases dealing with different thoughts, different schools. So you need basically to have a list of arbitration who are specialists on that field. The third thing, I also agree with what Dr. Naila said, raising the awareness, having the academy, for example, to provide courses dealing with the Islamic finance. This is one of the important things.
Thank you, Dr. Hassan, for addressing and explaining and sharing your experiences on such issues, and also encouraging institutions to bring up academies to promote Islamic finance disputes and knowledge base. With that, we turn to the last speaker for today, and he is Mr. Abdullah Abdul Rahman, who is joining us from Kuala Lumpur. He will provide us with the Malaysian perspective on Islamic arbitration under AIAC rules and the enforceability of awards.
Thank you, Abhinesh, and thank you, ADGMAC and AIAC, for having me today together with a panel of distinguished speakers, and ladies and gentlemen. I would like to state 4 points by way of introduction, and these 4 points will outline my discussion today. Hopefully, once I have set out the outline, I would already have made clear to those familiar with arbitration the issue with regard to enforceability of Malaysian awards in Islamic financial dispute, particularly in foreign jurisdiction, and how AIAC i-Arbitration rule, particularly Rule 11, may be in a position to address the issue. I will then briefly discuss each of the 4 points in turn to address the topic at hand, and hopefully this will be sufficient to provide some insight on arbitration as a choice of
Mr. Abdullah, we can't see your screen. Have you shared your PowerPoint presentation?
No, I've yet to share it.
Okay.
Yet to share it. Yes, the 4 points are, firstly, Malaysia is a party to the New York Convention 1958, and the particular provision I will focus with regard to enforceability is Article 5(1)(d) on refusal of enforcement due to violation of agreement of the parties on the composition of the arbitral tribunal or the arbitral procedure. Secondly, the Malaysian Arbitration Act 2005 is based on the Arbitral model law, And this means that the provisions giving effect to the New York Convention will be familiar to arbitration practitioners. Thirdly, I will refer to the Central Bank of Malaysia Act 2009, in particular section 56 and 57. And for this purpose, I will share my screen, because this is these provisions are important. I'm not sure whether you already have my screen. So the Central Bank of Malaysia Act 2009, section 56 provides for reference. It provides for reference to the Sharia Advisory Council, and this is the Sharia Advisory Council of the Central Bank of Malaysia for ruling from court or arbitrator. So what, if I may read, where in any proceedings relating to Islamic financial business before any court or arbitrator, any question arises concerning a Sharia matter, the court or the arbitrator, as the case may be, shall A, take into consideration any published rulings of the Sharia Advisory Council, or B, refer such question to the Sharia Advisory Council for its ruling. So it's clear that section 56 provides for a mandatory reference to the Sharia Advisory Council. Now, section 57, effect of Sharia rulings. Any ruling made by the Sharia Advisory Council pursuant to a reference made under this part shall be binding on the court or arbitrator making reference under section 56. So again, what it provides is for the binding effect of the decision of the Sharia Advisory Council to whom the arbitrator is required mandatorily to refer to. Now, the fourth point is the IAIC Islamic arbitration rules, and the particular rule and I'm referring to is the is Rule 11, which has been referred to by my colleagues earlier, but I have it in writing now for reference for the benefit of the viewers. So basically, I agree with my learned colleague earlier that this has to be read in a permissive way. But what it basically provides is this: whenever the arbitral tribunal has to form an opinion on a point related to Sharia principles and decide on a dispute arising from the Sharia aspect of the contract, the arbitral tribunal may refer. So this is what my learned colleague was referring to, may refer to the matter to the relevant counsel or Sharia expert for its ruling. Okay. And then the second sub-rules says the relevant counsel or Sharia expert shall be the Sharia counsel under whose purview the Sharia aspect to be decided falls, where there is one. And if there is none, then the Sharia counsel or expert as agreed between the parties. So in my view, section 56 and 57 of the Central Bank Act 2009 is quite problematic regard to enforceability due to a violation of Article 5, 1D of the New York Convention. These may pose a problem in enforcing an award from Malaysia if there had been a mandatory reference to the Sharia Advisory Council of Bank Negara Malaysia. Now, with that outline, may I now refer or discuss each one of the 4 points in turn. Now, the New York Convention basically provides for global enforcement of arbitration award, and as my learned colleague mentioned earlier, about 167, 168 countries are now members of the New York Convention, and this means that an award given in Malaysia may be enforced in any of the member states. So this is an advantage of arbitration over litigation because of the global enforcement of arbitration. The second point that I would like to highlight is the definition of arbitration, which basically means that it is a process by which parties agree to submit their dispute, and usually to a non-governmental decision maker to render a binding decision to resolve their dispute, and affording parties opportunity to be heard. And this feature, that it is a reference to a non-governmental decision maker, is an important one with regard to enforceability, because we remember that under the Central Bank of Malaysia Act provides for reference to the Sharia Advisory Council. Now, the Sharia Advisory Council is a council appointed by the government. In fact, it is a council appointed by the king on the advice of the minister. So in no way that the Sharia Advisory Council can be regarded as a non-governmental decision maker. The second point with regard to arbitration that I would like to, or second feature of arbitration that I would like to highlight is the various laws that are applicable. In an arbitration, the governing law of the arbitration may be a law which is not the law of one of the parties. For example, if you have two parties in international arbitration or international transaction, one from, say, Singapore, the other one from Thailand, they could agree that the dispute be governed by Malaysian law, for example. And this has been extended to also apply non-national law. In the case of Musawi, for example, in the UK, the English High Court upheld the decision of an arbitrator who applied the Sharia law with regard to the dispute between the parties. So this means that parties have the autonomy to decide on the law that is best suited to govern their dispute. There are also other matters which the parties may agree. For example, the qualification of the arbitrator who should hear their dispute. And this means that they may choose an arbitrator who is well-versed, for example, in Sharia. This may not be applicable or may not be available in court litigation. The next point is I would like to highlight with regard to the issue on the Central Bank of Malaysia Act is that stare decisis, or the principle of binding precedent, is not applicable in arbitration. So you do not have the issue, or you do not have the concern that a decision in an arbitration will be binding on the next arbitration. And unlike a court decision, for example, where the decision by a court, particularly the apex court, will be binding on a lower court or in other cases. So with this in mind, let me now highlight to you the article of the New York Convention that I referred to, which is Article 5. So Article 5 provides for refusal of recognition and enforcement of award if the composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties, or failing such agreement was not in accordance with the law of the country where the arbitration took place. Now, I would like to highlight to you the relevant provision of the Arbitration Act, providing for recognition and enforcement of arbitration award. Next, I will share also with you the particular provision of the Arbitration Act 2005, which applies the New York Convention, the provision of the New York Convention I referred to earlier. Now, I have referred to you the Central Bank of Malaysia Act 2009, which provides for mandatory reference to the Sharia Advisory Council and the binding effect of the reference to the Sharia Advisory Council. And in my view, the mandatory reference and the binding effect of the Central Bank of Malaysia Act amounts to a violation of the parties' agreement with regard to appointment of arbitrator, because as opposed to the arbitrator who is appointed, parties now are mandatorily required to refer to another party. And not only they are required to refer to another party, it requires a different procedure. Instead of the procedure before the arbitrator, the parties now have to refer or have to take the route of referring the particular issue to the Sharia Advisory Council. Next, we have the Rule 11, which provides for permissive mandatory reference to the Sharia Advisory Council. And in my view, this may be improved by providing for the binding effect of the decision of the Sharia Advisory Council as well. And why this is important, the reference to the i-Arbitration rules in effect is an agreement between the parties to refer the matter to the Sharia Advisory Council, or to permit the arbitrator to refer to the Sharia Advisory Council. And because it forms an agreement between the parties, it is arguable that this will not be in violation of the of Article 5 of the New York Convention.
Dear Mr. Abdullah, if you may give your concluding remarks.
Yes.
Thank you.
So, in conclusion, the parties and the authorities must be careful not to impose any provision which would violate the consensus of the parties, which would enforce delegation of the powers and duties of the arbitral tribunal, and which would involve state-appointed decision makers. And with regard to recommendation, I would suggest that parties be encouraged to agree on arbitral procedure, providing for reference to the SAC and the binding effect of its ruling. Secondly, the better approach would be to suggest amendment to Section 56 and 57 of the Central Bank of Malaysia Act, so that at least in arbitration only, referral to the Sharia Advisory Council by the Arbitral Tribunal should not be made mandatory. And where the referral is made, the SEC ruling should remain advisory. And this will be consistent with its nature as expert opinion. So with that, I conclude my discussion today. Thank you.
Thank you, Mr. Abdullah, for providing us with domestic insights on Malaysian Islamic arbitrations and its developments. With that, we conclude the webinar part of this session. I'm pleased to state that we have got much good feedback from the attendees, which we can see in the chat box. Due to the fact that we have overrun by 15 minutes, and we sincerely apologize for that, but the enthusiasm has been really encouraging. Before we proceed to the networking session, I would like to state that the webinar 1 has finished, but webinar 2 is to come. So the second webinar of the MESEA webinar series 2021 is on third-party funding, and it's titled "The First for Malaysia, but a Leap for Islamic Investors in MESEA Region." It will be held on 16 June 2021, and we will be joined by 4 capable speakers: Mr. Andrew Mackenzie, Ms. Anastasia Bondarenko, Mr. Dilip Masand, and Mr. Muhammad Ridza Abdullah. And it will be moderated by Mr. Adam Peters from the ADGM courts. With that, I conclude this session. Just as a housekeeping matter, now the AIAC team will slowly move each of the attendees to different breakout rooms. In each of the breakout rooms, you will have speakers and also AIAC case counsels if you have any questions. Thank you.